Hi, so this is a 5-minute recording to try to give a groundwork for my paper, which is called Uptake, Grounds Legal Status, but Be Careful Whom You Tell. Two basic overview things that I think would be useful to keep in mind before listening to the paper would be, first of all, that I'm basically accepting Searle's framework and Searle's understanding of institutions. I know that's probably familiar to most people who would attend this conference, maybe not everybody, but Searle's basic idea is that institutions are a device for, are a collectively intentional device for creating and manipulating artificial statuses, and those statuses carry what he calls deontic powers, which just means that they can create and alter people's rights and responsibilities with respect to each other within the context of that institution. So that's probably pretty familiar to most people at this conference. The other thing is maybe the debate between the legal positivists and the anti-positivists. So the legal positivists believe that law is basically a species of social fact. So it dovetails very nicely with, in general, with Searle's view. You know, that law is an institution. It's created by people. It's a set of social facts that depend on what they've done in the past or what reasons they have to get from what they've done in the past and things like that. And that's all there really is to law, that it's an artificial, if you will, normative system that people come up with. So, you know, it's an institution because institutions are artificial normative systems. The other side of the debate there, which is a little bit important, is what we might call the legal anti-positivists. These come in two flavors, two basic flavors. I mean, there's some differences within and stuff like that. Some are what you might call natural lawyers, which are just people who believe that law is not completely explained by its social facticity, if you will. That law has some element that is derived directly from reason, that we have, and that that reason can create a kind of standard for us to understand what makes good law and bad law, and what law is supposed to do is somehow to do something good for society, and therefore laws that aren't doing good things for society are necessarily deficient in some way, and maybe they're not even really law. There's some debate about that. The other kind of legal anti-positivist that you come across is exemplified by Ronald Dworkin. And he's what some people call, although he's sort of a natural lawyer as well, but he's what some people call a interpretivist. And his view is that it doesn't really make sense to say that law is just a species of social fact, because it's related to morality in a very special way, which is that we have to understand it in terms of the interpretations that people would give to it. In order to apply it, it needs to be interpreted, and that interpretation requires people to give it the best, basically the best, to make it seem in its best light. It has to fit with what people came before, but also be seen in its best light. And the best light is basically some correct understanding of morality, where correct morality is understood from, you know, that person's social setting. It's not, I mean, he does potentially believe in a, you know, he doesn't believe you can step outside your culture to decide whether or not your culture's morality is correct or not, although you can have some criticism and things like that. So those are the basic ideas. And in the next video, I guess I will present the paper.